Hey, welcome everybody. Hey, thanks for coming in and tuning in today on Zoom, and hoping everybody's keeping safe and healthy, and I hope everybody's been busy and having lots of deals as well. Today we're going to talk about commercial purchases and transactions. The last few times I've been here, it's been mostly residential. So we talk about all kinds of things dealing with pre-sales and purchases, and not pre-sale purchases and title searches and stuff. But so Calvin asked me to talk about commercial real estate. So we haven't done this before. And of course, I have a lot of issues and a lot of topics. Of course, if there's something you want more in further detail, maybe more elaboration, you can ask Calvin and John at Jovi, and we can do that in one of our future presentations as well. And I wasn't sure about how many of you have done commercial real estate purchases, whether it involves the land or just the business itself. And just, I think I was going to see if we can do a little poll, but do we have the results of the poll, Calvin, or? Anyways, we can continue, and some of you may have some questions. We'll have some time, and hopefully we'll get through everything and we can elaborate on more issues. My name is Iven C. I've been doing real estate for 22 years, actually more than that now, I think. Anyways, and in terms of real estate, when it comes to commercial real estate, all kinds of transactions, including some litigation as well. And when we get to certain points that I have in my presentation, I'll give you some stories of, I guess we'd call war stories of going through some contractual disputes when it comes to commercial real estate. Anyways, when it comes to commercial purchases, real estate issues, there's about 4 scenarios that can come to play. So we have a situation where your client is buying a business by buying the assets only. That includes an existing lease on that property, and therefore your client will become a tenant, or could be a sale. Second scenario is that your client buys a business by buying its assets, but the assets include the land itself, and then your client becomes the owner. The third one, where your client buys the land, which includes a lease or property and the lease on that property, and becomes a landlord to tenants. And then the fourth situation is where the client purchases the shares of a company that either buys the assets that includes the land, or just the business only. Now, I won't talk much about number 2 because a lot of the issues are more relevant to 1, 3, and 4. Okay, so the first scenario, or at least the first 3, buying a business with a lease or buying land that includes a lease. What are some common issues? And and the presentation today, I have a list of all these things that come up, and I don't have and at the very end, if you have time, I'll show you a typical contract that has some of these terms, but I want to highlight some of the issues that do arise and becomes a point of this, contention or perhaps dispute and negotiations between the buyer and seller. One of the big questions is, does the existing lease that's on the property, say, for example, you buy a property with a tenant on it, or you're buying the business where the landlord owns the property? So the first question, does the existing lease allow for an assignment of the lease in the first place? Quite often you see a lease term that the tenant has signed, tenant or seller, which says that the landlord can refuse it unreasonably and be arbitrarily refusing an assignment. There's a lot of leases say that, and some leases are saying that you have to get the landlord's consent, but the consent not to be unreasonably denied. That's another very common phrase. And some other ones have the reasons in which a landlord can deny an assignment. So it's very important to review a lease to see what rights does for example, if a buyer is coming in to have the lease assigned, and if you're representing a seller, of course, the same thing applies to see if what conditions that allow the lease to be assigned from your client to the new buyer. Um, so that's to take, some of the things that the landlords are particularly interested in for a new tenant coming in, or a new lessee is, well, can this person pay their bills? And that may involve credit searches. So if you're presenting an offer to a potential landlord on behalf of a client, it's probably a good idea to have an existing credit check already prepared for them to review. Quite often when I represent landlords, they ask me, hey, what should I be looking for when it comes to this potential tenant that may be buying? And so to increase your chances of approval, get a credit search done already so that you have the rating all ready to go. Of course, if it's, if the credit search that you've done for your client is not that good, then be prepared. You may not want to release it. You may want to do other things such as a net worth statement that shows how much assets that your client has, in case the landlord feels insecure about not being able to go after the tenant for future arrears, and if they don't pay the rent, etc. So that is quite often a reason for a landlord to either deny or accept a potential buyer. And you have these things ready. And I just mentioned something about a financial statement or net worth statement, so that the potential landlord, on behalf of a buyer, would be able to, potential tenant, to see how much assets they have in homes, and how much debt as well that the potential tenant has. I represent a lot of landlords where I do that evaluation. I get the credit search, the financial statements, and what I'm looking for to advise my landlord client when it comes to assessing a tenant is, how likely are you able to recover any deficits? How likely are you able to get paid from your monthly rents and obligations being met? So if you represent a seller, maybe, get that before the seller presents an offer to the landlord to approve or not, have those things ready to increase your chances of the sale going through. Okay. One of the biggest bones of contention when it comes to these types of transactions is number 3. Will the landlord release the existing seller tenant from the lease after an assignment? Often assumed and not allowed, meaning quite often people think, well, I'm selling my business, so I'm leaving. Why would I be on the hook? And quite often when I represent landlords, for example, and this is quite often not just myself and my practice, but the landlord wants some security. Like, what if the new buyer doesn't really know how to run the business? What if the new buyer does a different business that doesn't work out? I'd rather keep, as a landlord, keep this previous seller on the hook. And you have to look at the lease to see whether it allows it or not, and whether it's assumed, whether it's the seller, the seller or assignor of the lease, or can they assume or be safe that they will be released from the lease obligations even after the new buyer takes over. It's often assumed and leads to a lot of problems, like subject removal, subject to the buyer approving and being accepted by the landlord as a new tenant, as a common subject condition for asset purchase agreements. But little is it known that subject to for the vendors and for the sellers' rights to be released from the lease as well. Because no buyer, buyer doesn't really matter. Hey, I have another guarantor, no problem. But the seller, quite often, they don't want to be on the hook if the new buyer does something or runs off and has the obligation, that the landlord will then have a choice to come after the previous owner for the new buyer's obligation. So be very, very careful and make sure we look at the lease before you go to that route, and to make sure it's doable, and whether how likely is the landlord going to be released. On another note, when I have these situations, I've often, on behalf of, say for example, my client is a buyer, to negotiate with the landlord to find ways in which they can, on behalf of the seller, for example, to remove the seller assignor from their obligations under the lease. One of the things that I suggest is, well, wait 1 or 2 years and see how the new buyer works out. And after 2 years, then can you remove the current owner, seller, assignor from the lease obligations if the new buyer is in compliance with the lease? They paid up, and credit's good, they do the business well. put it right in the agreement with the lease with the landlord to allow them to break free. Otherwise, the only other way sometimes is the previous owner, seller, assignor guarantees the new buyer's lease until the time of expiry of the first term, but not any subsequent renewal. So it's important to see that. And another bone of contention sometimes too is who pays, item number 4, who pays for the landlord's costs of an assignment? Quite often it's right in the agreement that the tenant has to pay for all the costs, and nobody really thinks about it until they get the bill from the landlord when they've approved the assignment. Okay, here's my bill. I won't approve it until someone pays it. Of course, quite often at that point in time, the only contractual relationship is between the landlord and the existing tenant, aka the assigner or seller. So usually be prepared, and if you want to split the costs in the contract itself when you prepare it, any fees of the landlord will be split between the seller and the buyer on the statement of adjustments, and that relieves the burden, and so that both the buyer and seller, they both know if they get a bill, they know that they're going to split it. So quite often this is left out, not discussed, and then when the bill comes, there's a big problem, and then negotiations at the 12th hour. Quite often, the approval of the lease doesn't mean that the landlord isn't going to charge anything. Okay, so anyways, big issues. Now moving on, next item, number 5, 6, and 7. So another question that comes up is the security deposit. Quite often the seller, the signer, has a security deposit held by the landlord. So that's one of the questions that do come up. It has to be addressed and discussed. The seller quite often wants the money returned back to them, of course. The landlord has a choice. So usually the landlord is in control of that discussion. Landlord wants to keep it. And if that's the case, then the seller and buyer have to adjust it between themselves on the statement of adjustments. If the landlords agree to return it, then of course they have to get a new deposit from the buyer. Anyway, something to address and think about. Another question that comes quite often is, how is the price allocated? If the purchase transaction that you're representing a client is only dealing with assets, and there's a lease involved, then you have to think about how to divide the price between equipment, goodwill, and leasehold improvements. Now, one of the questions that come up is, what is the relevance? How important is it to have it? It's on every single contract for asset and purchase and sales, an allocation issue. And even if it comes to buying a land that's commercial, there's also a further element of allocation between the building and the land itself. So these things have to come into play. When it comes to assets, though, equipment usually is something that the seller is selling and as part of the business, but they usually apply for credits on their tax returns, for the corporate tax returns, for depreciation. So in their books, the value of the equipment may be a certain amount. So quite often when it comes to buy and sell, I would when it comes to an agreement between the buyer and seller, I would ask the seller, hey, you have to pay capital gains on the value of the equipment if you allocate it at a certain amount that's higher than your book value. So that's something to think about when you're representing your seller clients. They say, the equipment is worth so-and-so, but you check with their accountants because their book value may be different. You don't necessarily want to, usually as representing a seller, allocate the price for equipment greater than the book value on the books, based on your accountant. Goodwill is not taxable, that's one thing. Equipment is taxable under social service tax in BC, so that's a 7% tax. So think about that on behalf of a buyer. Okay, the lower the amount of the equipment value and asset purchase, the lower amount of social service tax, but also less room to depreciate the cost over time. Of course, leasehold improvements is not taxable either in terms of the social service tax. And it doesn't matter about all the price, but everything is GST applicable. So regardless, but it's just social service tax, which is a concern over here. And then number 7, material contracts will be taken over. Now, quite often your client, maybe if they want to take over the business as it exists, it wants all the same things so that the continuity will continue. So what kinds of contracts you have to see, what every business is different, right? So You want to look at the contract which makes the business viable to be run the way it is run currently. If you want to have it better, your client has plans as a buyer, that's fine, but as long as they know what is existing that helps the business run. One of the biggest disputes when it comes to clients over the years, the restaurant purchases and any business that requires a waste disposal company, huge bone of contention is garbage waste contracts. The contracts have a huge meaning that quite often the contracts that for these waste disposal are so convoluted and circular that it's nearly virtually impossible to break the contract. You need 2 weeks or 2 months notice. You need to find a way to get the new buyer to take over the first one before they disallow it. The new buyer comes in thinking, I don't want your contract, I'll just hire somebody new. Nobody considers the contract because it's 10 pages long with many tiny fine print. And if you read it, it's like a tax law. Everything is connected to something else and you can't unravel it unless you spend hours, and it's on purpose. Trust me, it's on purpose. When you look at the civil resolution tribunals and small claims court, it's clogged with cases suing and being sued upon by waste disposal contracts. They have clauses which says such as liquidated damages, which means a fee you pay if you break the contract illegally, etc. And they win, and they win. These contracts, they quite often win because of the way they worded it. It's nearly impossible to break out. Be very careful. Of course, if you have a business which is not a restaurant related, then quite often you don't have to worry about those contracts. You worry about other things such as leases, business insurance, business license, liquor license if it's a restaurant again. Some concerns that it brings up when it comes to these contracts is equipment. Quite often businesses rent or lease their equipment. Because they rent or lease their equipment, then of course then they have to take over a lease or, and sign up on the lease company that has different deposits been given in terms, so you have to watch out for that. I write down in my PowerPoint PPSA because quite often when you lease equipment, there's a loan and loan payments for that equipment, and they register that against the company that your client, if it's a seller, has, so that someone can see there's a lien registered against the company's assets. And that's very common. So make sure that whenever there's equipment being purchased, that you check a PPSA of that, as one of the due diligence things to think about on behalf of a buyer client, to make sure that the equipment really is belonging to the seller and is able to be sold to the buyer, okay? And of course, searches for PPSAs using BC Online, and you can always hire a lawyer, a notary who has access to that to do the search. I'm not sure if the brokerages, maybe Calvin, if you can answer whether real estate brokerages have access to PPSA searches on behalf of agents as well. You can tell me later on. Anyways, liquor license, that's something that's going to be big problem as well, because companies that are buying a company wants to take over a liquor license. One of the requirements is to disclose who has a share in the company that is defined as a 25% or more of ownership of the company that is taking over the license, and they have to be disclosed, and then the fingerprint and criminal records check search to make sure that they're able to operate and have an ownership of a liquor license. So that's something to consider. Okay, and next items, what due diligence? This ties into what I just mentioned. Like you're acting on behalf of a buyer, what things you should do to check on the seller. So PPSA, like I just mentioned, WorkSafe BC, these are different things that are, especially the government departments like WorkSafe, corporate capital tax, employment standards, and each of these things, some of them cost more money than others. Like city bylaw searches, they're expensive. City of Vancouver, I think, is around $600 if you want to see if you're buying the business and whether the business is in compliance with bylaws. So there are existing charges against them to fix things, or the patio sticks out too far, their sign is too big, or whatever. You want to see if the business is in compliance, because you might inherit the requirements to fix your business. It may be too late afterwards to do it. Fire department, Health department. These are all really important departments to look at. GST to see whether or not there's any GST filings have been up to date and paid or not. Anyways, these are all things that as a buyer you want to check either before you remove subjects or even after. If you do a removal of these things after, it might take some time. So just make sure you're aware of that, the time frame between subject removal and completion date. You want to have enough time to search these things. And if it's not enough time, then if there's no time to check and you have to complete, that's a problem, okay? On average, GST, social service tax, they're pretty quick, and that 2-3 weeks is a sufficient time. But some departments take a lot longer. On that list that you see here, technical safety BC, it takes a while. Now, last year, for example, I had a client that was buying an apartment building, and they have to make sure that the boilers are in operation and fully checked, and make sure the elevators are all in service and all in check, and they've complied with all the requirements to fix the boilers and the HVAC. It takes time. So if you don't have enough time, then your buyer client may be in trouble if they don't have any provisions for that, okay? Other things such as if it's a strata building, you want to look at the bylaws and the strata forms and stuff to make sure that your client can actually run the business that they're proposing. And not only that, right now, for example, I represent a bubble tea franchisor. They're running a bubble tea franchise in Richmond, where after they bought it, the strata says, hey, we can't let you have that sign. Because it doesn't look like the rest of the stratas in our strata complex. And of course, the franchisor says, that's the brand. You can't change the sign. And so there's a huge dispute. We've been ongoing for over a year dealing with that issue. So check these things, not just the nature of the business, but the rules for the size and the signs and the way and everything looks. So something to keep that in mind when you're representing a buyer. Financial statements, of course, you want to see if the income that's generated by the business on behalf of your buyer fluctuates with time, or is it a gradual descent going down from month to month, year to year, or cyclical, so that the business goes up during the summer, goes down during winter, but that's normal. Every year is the same. So you have a pattern you can explain to your buyer client as to the subject business that your client is buying. Something else to look at, estoppel certificates. So if you're buying a business and you're buying land, this is a situation that's particularly important. You're buying a building which has tenants, and your client will become the landlord. You want to make sure that all the tenants and there are cases, how would you say, there are issues with the landlord are all taken care of. And then you ask for something called an estoppel certificate. Now, what that means is that the landlord or the seller would have to get their tenants in their building to sign documents to confirm that there's no issues. Everything is up to date. There's nothing outstanding. There's no ongoing obligations and liabilities from the landlord to the tenant and vice versa, so that your client becoming the landlord will know that there's nothing that will bite them in the butt after they buy the land. Question that comes up quite often is, can they be required? Well, that's where you have to look at the lease. Quite often, the landlord will have in the lease a specific contractual term that allows the landlord to require the tenant to sign estoppel certificates when required. If they don't have that clause in, there may be other lease clauses that allows the landlord to require the tenant to comply to allow the landlord, the seller, to sell and market the properties to other buyers. So important to look at the lease again. Even if you have your buyer client wanting to get an estoppel certificate to satisfy that there isn't going to be issues with the tenants later on. Okay. Question: should there be holdback for due diligence? I mentioned that it takes time to do all those searches, like all these ones I mentioned before in a previous slide, right? It takes time, and if you have a short completion from after subject, like 2 weeks, they may be not enough. The results haven't come in. Like after you buy it, then you get a city bylaw department saying that you got to fix this and change that, and it costs $10,000 to do it. Or the patio is not in compliance with the bylaws, and you got to shrink in what you thought was a big patio, but it's a lot less than you really thought. I had one client that after they bought the restaurant, they didn't want to do all these things, and there was a 2-week completion, and there's no holdback. The health department says you got to install a whole separate hand washing basin separate from the cooking area, and it costs $10,000 in 3 weeks maybe by a contractor to actually do it. Well, there's nothing to get back from the seller. So, and when it comes to holdbacks, yeah, if there's not enough time, put a provision there for certain funds to be held back, so that if something needs to be fixed, there's a time frame to fix it. And if it's not fixed, then the funds can be either released to the buyer to use that fund to fix whatever needs to be fixed. It's hard to predict ahead of time, of course, how much that should be. So anywhere I've seen averages from 5,000 to 10,000 holdbacks, and there usually should be a time frame. You don't want to have the seller, hey, I got 2 years to fix something. So you want to put a time frame on it. And if you can do it just like regular real estate holdbacks when it comes to homes, put a value for each thing if you can possibly do. So if a dollar value and a fixed finite time frame to fix things done, and if not, just take the money and go and take care of things. Okay. So the holdback is advisable if you can swing it, get it into the contract, especially if there's short time frame between completion and subject removal. Of course, if you have a long time frame for subject removals, to search before subjects even better, but that's not always practical when it comes to business sales and purchases. Something else to think about: hiring existing employees of business or not. And your new buyer may want to take over the business and keep it running, and the employees are perfect. Hey, they know the business, they can run it, they know what to do. But be careful, especially for long-term employees, because if you take over the contracts of the employees, you also, as a new buyer, become your client, the buyer, becomes liable for example, severance pay. The long-term employee has been working for that business for 10, 15 years. And when you take over, business is slow, or so your client takes over, business is slow, and you say, hey, we got to let you go. You might be liable, the client may be liable for severance, for a long common law claims of severance pay that's greater than 8 weeks of maximum of severance pay that's under the Employment Standards Act. So yeah, be careful. So quite often I recommend when they do an asset purchase and you want to take over a business, take over existing employees, have it as a term of the contract that the employees are fired by the seller and then rehired by the buyer. So everything starts new, okay? And then another big question comes up is, how will rent be adjusted? So there's cases where there's a gross lease, which means everything's all included. The tenant pays one rent payment, and that covers everything. There's nothing extra to be adjusted. But sometimes, and quite more common, is a triple net lease where certain prepaid expenses are paid over time. And then you have to ask the landlord in this situation, how much has been collected, how much is over not paid yet or overdoing. So when you have these issues, want to make sure that the adjustments covers anything that the landlord has collected or not collected enough. And that requires coordination with the landlord, and have all these items adjusted on completion date. Okay, so just things to have your clients as a buyer to be aware of, and to look into and to inquire. Okay, especially when they're taking over a lease. They want to make sure that any debts that the current owner owes, your client will then benefit from having the landlord confirm exactly how much needs to be collected or not. Okay. Another issue here is, besides that, is the length of the term remaining. Quite often, your client buyer wants to recover their costs they put into buying the business. And if they only have a year left, and it's not very good time enough to recover your costs, or your client's costs. You want to have a reasonable amount of time, and don't accept it if it's 2 years into a 5-year term. It never hurts to ask on behalf of a buyer client, not just as a buyer to be approved for assignment of the lease, but to amend the lease further, to add another couple of years to at least make it 5 years, for example, with a 5-year renewal. So if you can swing it on the subject conditions, subject to the purchaser arranging for a brand new lease or assignment of the lease and being approved by the landlord with amendments to make it a 5-year and 5-year renewal type thing. And that's a good thing to have so that there's time for the buyer to negotiate with the landlord before subject removal, okay? Next couple of points, number 4. Oh, gee, I did the numbering wrong here? 1 second. 13, 14, yes. Are there any options to renew? I just mentioned that just a minute ago, like a 5-year term, 5-year options is really good to have an option. Quite often, options needs to be exercised. There's quite often a clause in the leases which says 6 months prior to the end of the lease, the current owner has to notify in writing to the seller as to the notify the landlord whether they want to renew or not. That's very, very important. One of the war stories I want to tell you about is a client of mine who was leasing out a unit to run a Chinese medicine store inside T&T. And the manager, property manager, would come by all the time and say, "Hey, how you doing? How's business?" And then 6 months prior to the end of the lease, he did not send something in writing to the landlord, but he spoke to the property manager guy who walks around. "Hey, you're gonna renew? Yeah, sure, no problem. Da 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 da." 3 months in, the property manager changes and moves to some other location. And the landlord sends my client a notice saying, "Hey, after the 3 months is up, you have to be out. We've got a new tenant coming in." And so my client said, "Hey, wait a minute. I've been verbally telling the property manager that I want to renew." But then when they came to me, we have to read the lease. What did the lease say? Written notice. And this is a warning that you can't rely on just verbal things and talking. You have to have written notice. And a written form could be text, could be email, could be a letter, couriered, still written rather as opposed to verbal. When we eventually went to court, we were able to locate and track down and find the property manager somewhere in Ontario to give evidence. And so the judge gave a little bit more time to my client, but he says that written notice, that's what the contract says. It's black and white. It says written notice. You have to follow it. So commercial contracts, they give a lot of credence to what is actually written. And if it's clear and it's black and white, it's there, written notice. You can't get around it. It's not, not verbal, not understanding, and not a video clip. And the video clip is still not written. So you have a video. Look, I got recorded my conversation with the so-and-so. It's still not written. So they gave a few more extra months to my client to clear out, but at the end of the day, he had to leave because he did not give written notice. Okay. So war stories from litigation. Anyways, restrictive covenants, are they enforceable? What are these restrictive covenants? Quite often when your client buys a business, the seller promises not to run another similar business that's competing with your client's business, and therefore that they can operate their business without competition, based on the goodwill that the previous owner has. So your client wants to be protected. This quite often, there's a few more war stories that come from this kind of issue, is that if the restrictive covenant is ambiguous and not too clear, then it could be with void for ambiguity. And now you think that what can be ambiguous? For example, I give you a case that deals with Iris Optical, this big chain store, and they had a restrictive covenant, and when they purchased the place, and said the seller could not, the previous franchisee could not operate as another business in competition that has eyewear, okay, glasses, optical. And so when it was challenged, one of the ways in which the person who the restrictive covenant was being forced against was saying is that, well, I could be like London Drugs, where I have an optical department which comprises of 2% of the whole entire store, and that would still be competitive to an eyeglass store. And then the court struck that restrictive covenant down as saying it's too ambiguous. because it could include all kinds of things. And you think that it's clear as long as you sell it, but so a better way when you deal with restrictive covenants, when you're acting on behalf of a buyer and you want it to be enforceable against the sellers, to make sure that it's clear. Now, if you put percentage down, that makes it more clear. The departing seller cannot open a business within 2 kilometers of the location where you operate the business, where X percent of their business comprises of that business that is being sold. So where they can no longer operate an optical department where the optical sales and distribution does not occupy more than 2% of their space or 30% of their business or income, et cetera, et cetera. So pick a number, put it in, and you'd be much more safe than the other way that I just mentioned, okay? Another thing, what are the kinds of taxes? I mentioned that before. We mentioned, for example, social service tax applicable on equipment being purchased, the 7%, GST on the total purchase price. So GST has to be talked about. One thing to notice though, if the buyer and the seller have GST, they can jointly elect to not have the GST paid because each of them would have their own GST returns to deal with that. Okay, so something to think about. And if one party has a GST but the other one doesn't, then you have to, the GST has to be paid, okay? Social service tax, capital gains, I mentioned that about equipment cost, the book costs and the seller, they may have a value different than what the agreed cost and allocation of the price. So watch out for that on behalf of your seller client. If you have a client that's selling and they say to you, and this quite often happens. The seller says, I don't care, whatever the buyer wants, we'll let them decide. So, there's a question, you may want that to happen, or you want to tell your client, hey, you should check with your accountant and find out what the book value is before you do that, okay? Withholding tax, look, of course, a non-resident seller of real estate and businesses, anything selling something that there's a withholding tax, you better watch out for that too. So the representations are important. When you're selling, buying at the very end, you write down tick or not tick. The seller is a resident or non-resident of Canada, because the CRA makes the buyers the tax collector, the sellers the tax collectors for CRA. And if you don't collect the withholding tax or make arrangements, then the seller could be, the buyer could be liable for what the seller owes. Okay, be careful about that. Now, the last thing here, the leases. You do the searches. You find out that the lease is under 3 years or over 3 years. So what is the significance? The significance is that 3 years, leases that are under 3 years doesn't have to be registered to be effective against other people when claiming interest and ownership on title. What that means is mostly visible, or how would you say, clear when it comes to foreclosures. Okay, and I want to bring up a case. If you guys want to email me and I'll send you this case. This is called Institutional Mortgage Capital Canada versus Plaza 500 Hotels. Very important, because in this situation, it was a long-term lease, but it wasn't registered. It wasn't registered on title. We can talk about registration, what it means, and I've done that once before. I think with Strovi, we did a presentation on title searches, and it pops up. What does it mean when there's a lease registered? And in this situation, there's foreclosure proceeding by the lenders, and they had their mortgage registered on title. So their mortgage takes precedent over any lease that's not registered, first of all, just prima facie because it's registered. Even if there was a lease signed between the tenant and the owner, it doesn't work against an unregistered lease. It takes less priority over a registered mortgage in favor of the bank. So in this case, the tenants had challenged it, saying that we have a lease, we've been having a lease been renewed over and over, and But what you have here, and this is a British Columbia Court of Appeal, so you can't get much higher than that, other than Supreme Court of Canada, saying that unregistered leases don't have any priority over these institutional lenders registered on title. Now, if the lease was a 3-year lease, under 3 years, there's protection, but anything over 3 is not protected. It has to be registered in order to have priority over anybody else. So that's important to think. Now, one problem that is normally encountered though when you're buying and selling businesses and there's a lease involved, landlords usually have a specific term in the lease that says the lease is not to be registered. There's no obligation for the landlord to register the lease. So quite often the landlord then is free to not be unfettered and be bound to the tenant. So something to think about, something to consider, that if there's no reference and there's nothing mentioned about whether the tenant can or cannot register the lease, it's always better protection if you can and find a way to do it. But if not, then that's the risk. Okay. And this is a good case because it's really recent, 2020, last year, and it's Court of Appeals. Okay. Now, a couple more things. 18. You have businesses that are in a strata, businesses that are in a building where a whole bunch of other units are being rented out to the landlord, and also cooperatives, and also shopping center lease or standalone buildings. These are all different situations when you might come across, and they all have different considerations, like different issues that pop up. For example, strata fees and special levies when it comes to buying, who's responsible to pay, rules when it comes to common area, expenses on common areas, restrictions to prevent competition. That's very important to look at, to review. Sometimes, for example, malls, they don't want to have 15 coffee shop companies competing against each other because it reduces their ability to get percentage rent overall. They may have restrictions, only one coffee shop or two, or one pizza store, or one sushi restaurant. They watch out for these things. I had a client that tried to operate a poke place in UBC, and the students have a council where they meet and decide what's good for the students overall. And they said, no, we already have a sushi restaurant, even though, poke is very different than a sushi restaurant. So you have to watch out for these things, and subject to approvals by the strata, subject to approvals by the council. If it's a cooperative and a student association run, like you have a lot of leasehold businesses on UBC and SFU as well. So be careful about that. Opening hours as well, like when you're in a mall, especially, you have required opening hours. So your client better be prepared to, be not in breach of their contract, because they take those seriously. You leave it vacant for 1 or 2 days in shopping centers, that's enough to consider a default and kick the tenant out, the default under the lease. So be very careful. Every one of these types have different issues. Now, one thing issue that comes up is item B. When you have a business inside a building that has other businesses. So why would you want to share, for example, on your behalf of a client, based on square footage, which is the common way it's done? If your client wants to buy business that's 10% square footage, then quite often the rent is for those costs for common areas. 10% of the cost of the common area cost is covered by that tenant. But if it's for water, and your client wants to run a bookstore and the next door runs a restaurant, then it's quite unfair. You pay 50% or 10% of the water cost, but 90% of it is used by the other tenant. So be careful and be conscious of that, those types of situations. And of course, those things don't exist for the standalone building, but standalone buildings, you have to think all the costs usually are borne by the tenant. The landlord may or may not cover things such as roof repair and HVAC and boilers and snow removals and all those things that might be all on the tenant. So watch out when you get the financials on behalf of a buyer, to buy to buying a business, to make sure that what's covered and not covered and how expensive is it. Okay. Percentage rent, that's usually something item is in malls, in the shopping centers, because not only do they have rent for basic rent, which is per square foot based on usage, and then additional rent, which is based on how much property taxes and all that on top, and operating expenses, and then on top is another level of rent based on how much profit they make over and above the basic rent. So be careful, and these things can add up if it's really something on behalf of your buyer client, to make sure that they're aware of and know how to calculate. Okay. Now I'm almost to the last screen. I think 19 other common terms and issues to think about. Demolition clauses. If you can avoid it at all costs, try to remove it. Usually what means is the landlord, the owner has the rights to cancel to terminate the lease if they want to demolish the building, renovate it, sell it to a developer who will then renovate and demolish it. Usually the time frame is not that much, 6 months to a year. So if you can avoid it, because they give your clients notice, so you sign up to and take over the lease and buy it, and then they give them 1 year's notice. Basically, a 5-year term lease. Now it's like 1 year's to make up their money and leave and lose all their investments. If there is a demolition clause, they try to negotiate so that it goes after a certain point of time. So when you can not just subject removal to the landlord approving the buyer as a tenant, but also to agree to extend the time frame for a demolition clause to take effect. So a demolition clause will take effect after 5 years of the current owner buying and then leasing the business. And even though it's in the lease agreement that the seller just gives 1 year's notice, you try to put a specific term to say, yes, 1 year's notice, but after 3 or 4 years or 5 years of running the business to protect your buyer client. Okay. Overholding clauses, of course, there's usually under when there's options to renew. You want to think about what is the new rental rate during the option, the renewal phase of the lease. And if they don't come to an agreement, then usually there's a clause in the lease that allows the landlord to charge more rent or double rent, or the lease becomes month to month. Something important to look at on behalf of your buyer client when you're looking for an overholding clause. Then rent becomes automatically double or 110% if there's no agreement, and the buyer doesn't want the tenant to leave. I mean, the landlord, and the tenant, and the new owner doesn't want to leave either. And then you have a default rent, which is quite often higher than the existing rent at that time. Guarantee or indemnity clauses, like I mentioned to you about, not being the current owner. If you have a client who's selling a business and all of a sudden being required to guarantee or indemnify the buyer until the end of the term or the lease of the lease term. So watch out for these. Make sure that it's aware of who's going to be a guarantor or not, and how long it will last for. And also look for this term that's quite often in leases where it says that it's absolute net lease to the landlord, meaning none of the landlord's costs will be swallowed and taken care of by the landlord. It'll be forwarded to the current tenant to pay, including capital alterations, structural repairs, and all of it ends up to be something that the tenant pays. So watch out for these ones. And if there is, if your client does, one of the subjects is to inspect the commercial inspection, and they find out that, hey, the roof is going to, leak in about a year or two, you may want to carve some exceptions to that so that the landlord is responsible for this or that, and not the tenant, and the cost for the fixing won't end up on your client, the buyer's obligations to pay. Tenant versus landlord repair costs, just mentioned that. So it's very good to be clear who's responsible for what, and to make sure that your client knows it as a seller or buyer. The seller, if you're obligating to guarantee the buyer, and the buyer, if they know what they're taking over when they take over. Okay, I think that's it. Is it? Let me see. Right at first, these are. I just want to do this quickly because if you guys have more time to go after two, that's great. And then I have lots to say and we can spend more time on it later. But right of first refusal to purchase, an option to purchase, these are quite common, and it's nice to have that if you're a buyer who wants to buy a business and has an option to buy the whole entire building later on if the seller wants to give up and sell the business and become switch the landlord role to some new buyer. If they have this in the clause, that's really nice, and the buyer has an option, but they have to match usually the price that the landlord is willing to accept when it comes to a sale. An option to purchase, that means it's in the control of the tenant. And when they have an option that they can choose and exercise the option to purchase the building from the landlord, and that's less common than a right of first refusal, but it's still there. And if you negotiate that in, gives the tenant the control, the buyer who's going to take over a business, control over when they want to pull the trigger to see if they want to buy the whole building or not. Arbitration clauses are always good. Usually this is in the context of any disputes over the interpretation of the lease contract, and especially when it comes to rent. Okay, so if you have a lease and your client has a lease, and You want to have sure that there's ways to arbitrate the differences rather than going straight to court. So it's a good thing to have. And on behalf of your client, if your client is taking over a business and they're going to renovate and become something new, or they're going to substantially renovate, they're adding value to the landlord's business overall. I mean, they're own the land. So you might want to negotiate a free fixturing period that allows your client, the buyer, to not have to pay rent or basic rent, additional rent, gross rent for the time that they're fixing, accessing, changing, renovating. Okay, something good to have to negotiate. And there's lots of terms and clauses that deals with that, and we can get to that some other time. One other thing too, when it comes to fixturing, is your client wants to, spend a lot of money to renovate this and change that. You want to look at the lease very carefully to see whether or not anything added to it becomes a property of the landlord. And this where it comes to the definition of fixtures versus leasehold improvements. The measure is that if your client wants to do renovations which alter the foundation or alter the walls, and it becomes hard, really hard to put back into the same condition as it was when it was purchased, likelihood is that those additions and alterations are considered leasehold improvements and belong to the landlord, as opposed to chattels or fixtures, which can be removed as well. Okay, so easily removed without leaving marks on the walls or holes and screws and pipes and things exposed, etc. Okay, something else to think about. Now, purchase and sales of shares rather than buying the assets. And this is a really complicated one. It has a lot to do with corporate stuff. When I represent clients, there's other things to think about other than just what you see, physically. So some things you think about, I'm going to run through this, the 3 issues that comes up. Assignment restrictions as well. Sometimes the lease says that even the change of control of shares is considered an assignment and needs the landlord's consent. And so because the landlord sometimes says, hey, I want to know who the shareholders are, and if their credit's bad, I want a new shareholder to guarantee the lease. So that's something to think about. Not just taking over an asset, but just when shares too, you need to really see whether the landlord needs their approval or not, and whether it's allowed or approved and easy, or their conditions or not. So same thing as buying an asset purchase and looking at the assignment clauses. Okay. Another thing is the difference between the two, why we want to buy shares versus the assets themselves. The main thing usually is that is liabilities. There could be unknown liabilities that the seller has, that the owner assumes the liabilities, becoming the owner, becoming the new company owner, and they assume all those liabilities and say that, yeah, but I got an indemnity, which means I can go after the seller afterwards. But, quite often, maybe what happens is the seller, gone to another city or country, retires, and their, flight restrictions are gone, they're off to Tahiti, and you want to chase after them for an indemnity. It may be tough and hard, and you may be hard press. And meanwhile, CRA is saying, pay up, buddy. But you got to pay up front first and then go after the seller later. It's quite often, and I have a buyer client, I say, well, don't buy the shares because you don't know what's going to be hidden. And that is obviously if a business has been in operation for longer. There's more chances for liabilities to occur and lurking around the corner that you didn't know about, including employees that were injured and they didn't sue until 2 years later, which they have a time limitation. Well, how do you check for that? If they didn't make an employment standards claim and they didn't go through WorkSafe BC and they didn't have insurance, and they just be lurking around the corner. Anyways, be careful. So basically, the main difference is liabilities. When you take over assets, you're not becoming the business, you're just new. So be careful. And if a company owns a land, one thing that's a benefit sometimes is that, hey, yeah, no PTT. You don't have to pay property transfer taxes. There's no transaction at the land title office. Okay, so that's something that becomes, when you weigh the pros and cons on behalf of a buyer, do you want to share or do you want assets? Okay. Third thing, I think this is my last slide. Is it 3? Nope, 2 more. Sorry, sorry. Going on here. So what should purchase price for shares specifically include or make clear? When you buy shares for a certain price, you want to make sure that the price include things or not include things. You may think that includes everything, but common business principles, usually the shareholder loans are not included. You may buy it and think you own everything, but the company has money that they have to pay shareholders first, and it's not included in the price. Then if you didn't take care of that and didn't write that in your contract, then you're going to have problems. Usually physical assets are more clear. The owner is the company. The owner, you buy the company, you own the assets. But there's certain things such as rights, accounts receivables, and loans, leases, and things like that. Cash on hand and inventory. Do they own that? For example, credit card bills, and that the bill doesn't come till later, and it's already been spent before. Does the bills included? Is not included. Prepaid expenses such as property taxes or leases. For example, I have a lot of clients of mine who are buying farms. And in the farm, they have a lease with the corn grower guy that comes in and has a contract for a certain amount of dollars to be able to reap all the corn when the corn season's up. You may buy it in March, and then all you see is a bald patch and little shrubs coming out. But in like 10 months time, you got these huge stalks with corn, and you say, hey, sounds like I got corn, but no, it's a lease. And there's a leaseholder that's subleased the little plot to grow the corn. They have rights to split the profits, but not allow the landlord or owner to take over that part. So watch out for these things, and some things been paid for it already. So watch out for these. Of course, there's the other usual things such as leases, security deposits, rent. When you're doing investigations on behalf of a client, you want to look at everything to make sure what's in and what's not. And if there's any dispute, put a clause in, right? One of the things I mentioned is that the lender sometimes, or the seller, sorry, sometimes there's so many things that they don't remember. And then the buyer doesn't know, and the buyer doesn't know what they need. So you might want to put in the contract that, the buyer will take over things that they agree to once they're disclosed and once they're found out. And otherwise, everything's in unless it's excluded, or everything's excluded unless it's in. Okay. Last thing, and sorry, it's taking an hour, a little bit more. What to check for? Companies. You want to make sure that they're in good standing. Have they filed their corporate annual reports? You might want to look at their book. And it's very important to know that the company is properly constituted. Like someone has reported on the BC Online or corporate online, their director, but you check their books and there's nothing that suggests that they've been appointed properly, or that nothing to confirm they've accepted it, or something. You want to make sure all the documents in the book are in order. Financial statements, like I mentioned, for both asset purchase and share purchase, GST returns, especially when it comes to a share purchase, because you assume the GST obligations of the seller. You make sure that it's fully paid for, filed. And property tax, the CRA notices are returned, and the corporate tax returns follow the notice of assessments. And so, not just the tax return, but the notice assessments, which confirms whether the tax returns are accurate or not. So make sure you get all of that. These are all things that you don't really necessarily need to do that if you do asset purchase, but you have to do that if you share purchase. Okay. I think that's it. Yep, that's it. And that's a nice little snapshot of all the issues that come up. And trust me, there's more where that came from in terms of issues. But we're at the end. We can open up to some questions. And Calvin, if you can direct and you can point out questions, if or if you can unmute somebody, they can ask the question, whatever you choose.
Ivan, there's a question.
Yep.
It's called social SVC tax for equipment. Is there a value limit for equipment like over 10K, etc.?
Maybe the question is the tax applicable only when it reaches a certain amount? No, it's not. It's as soon as there's equipment and there's a value assessed on it, then the tax is applicable. There are some exemptions. For example, if you're buying a noodle factory where all the there's, for example, in previous years where the equipment used for the noodle, something that has to do with the fact that they're intrinsic part of the building. You can't remove it, pull it out. It's all in there. Some kind of a technical exemption. It hasn't come across it too often, but there are some exemptions. But for the most part, if it's worth something, there's a tax. So, yeah. Any other questions? Thank you. That was Sophie's question. Thank you, Sophie.
Oh, hi, Ivan. This is Joanne.
Oh, hi, Joanne. Hey, gotta get the blueberries from you.
Yeah. Okay, I have a question. Is right now I have a buyer who would like to buy some of the property in Richmond, but the title seems very complicated. We read over the document and found out only 44% is belongs to the strata lot, and 56% is belong to LCP. And so do you have any recommend what kind of things we should look after? Because and
Is this a
how to,
commercial? Is it a commercial lot? Commercial property?
yes.
Yeah. So one of the things to make sure is that before subject removals is you look at the strata plans to see the limited common property is how is it specific, how is it specifically assigned to the client? Because exclusive use of that that client that's selling, I mean the seller, right? You want to make sure it's there and exclusive use. If it's not exclusive use and a certain segment of the strata owners have access to that same area or portion, then you want to make sure what's in it and what's not. Yeah, so you need to do further due diligence before you know what you're going to get. It's hard to remove an LCP, like to designate it and redesignate it. I think what you have to have for LCP is a special majority, I think, or greater than special majority in the strata. So you better check as part of the due diligence and before subject removals to check the strata plan and to see the status of that 56%. So.
Okay, so the other question is because the 56 more than 44, right? So what do you think this kind of property is? How,
Yeah, you know what I would tell the buyer is that you have 56% of that property at risk potentially if the strata, councils vote and say, hey, we'd rather designate it for this or change that or add some rules towards it. So, like you want to look at the rules for LCPs for that strata and what do they say about it? For example, it could be a parking lot that three other strata commercial units use. And it's LCP for those three strata units so that the rest of the 15, they can't have their cars parked in that parking lot. But there can be rules set for that section of the LCP. So, no trucks are allowed, no delivery trucks and this or that. And so you want to make sure what the rules are as well. So, and the value is that associated with the purchase is that, hell, yeah, there's rules. You don't control everything in it. You still, strata, you have to follow bylaws, but now you have more things to think about on behalf of your buyer client,
Perfect, thank you. I think
Yeah,
it's a better set appointment with you, yeah, to read over all the detailed stuff. Thank you.
Yeah. Oh yeah, you're welcome. Yeah, well, thank you.
Hello, Ivan.
Yes. Oh, hi, Frank. Thank you.
Yeah, that's Frank. I have a client who's looking at a piece of land in Richmond where he can build a retail space downstairs and office upstairs. If the zoning is not right, what is timeline we're looking at if he has to apply for rezoning?
Well, Richmond zoning, boy, your client is looking to buy or they already own it, thinking about building.
He's leasing an office space for now, but he thinks, well, what appreciate is the land, it's not the building. So on long term, he likes to buy a piece of land and build something of his own.
Oh yeah, well, the zoning process is well, an easy answer to that is not very short. The reverse is quite a long time, but there's no, I wouldn't be able to estimate. I won't advise clients how long approximately with changing zoning would happen. It's so many things that are political about it too, council meetings and approvals, and you have timelines for approvals. And I just finished dealing one just recently where we were trying to meet a deadline for council to make the decision. The city has done their searches, investigations. They're recommending a certain zoning change so long as we do something and they approve something. and we were rushing in hell and high water to reach the time frame, to reach the timeline that's given to us by the city manager. And then all of a sudden, we send it all, and the meeting happens, and then we get the results say postponed until September. It's like, what? It's like my client's waiting a year and a half, 2 years, and now they have another 9 months. And what happened? Oh, because the email got lost in their spam. It's like with all the documents. Now you have to wait for council to have another putting that back on their agenda to vote on it, or have some kind of a meeting about it. And right, so really, there's so many factors involved that I don't give clients who are planning this a timeline. If you have a long-term, a 5-10 year time frame that you're willing to wait, invest, and pay your property taxes in the meantime, by all means, if you have patience and if you have the financial means to do it. In the meantime, yeah, it takes a long time. There's a lot of.
I think I better recommend him to consider the right zoning.
Oh, spend the time to find it. It's better time to find something and changing zoning. Way better, way more predictable.
Okay.
Yeah. Even even if you look at it and you say, hey, right next door, they've been running this, whatever it may be, for the last 15 years. Of course, it must be allowed. Don't even assume that. I just had a client that 20 years of running this particular operation. I won't name it, but then they were notified. Oh, by the way, we noticed that that you don't have zoning. So we've been business licenses for 15 years and running it openly, and then now you say that there's no zoning. It was unbelievable. But while it's there, if you research it and check it, you're off by 1 block. And right next door, it doesn't matter. They haven't prosecuted them. They're only picking on you, right? Your client or whatever. And then you have to fight, and it's awful, so in situations you can't assume things, and even if it looks like it's approved and business license approved, that there's sitting on zoning that wasn't really allowed, right? It's crazy out there.
Okay, thank you very much, Ivan.
Yeah. Tell your client to spend more time with you to find something within the zoning.
Okay, I will.
Yeah. Okay.
Thank you.
Yeah, you're welcome, Frank. Any more questions there? It looks like we're good. Calvin? Oh, I think I was gonna do a draw. I don't know if you've been here before, you guys, when you entered a draw. I don't think Calvin mentioned it. So hey, it's a gift certificate, gift certificate from Amazon. Sorry, I choose Amazon. You might want to have someone local, but I tried really the ease in which I can just send a gift and to you guys with your Amazon. Okay. So anyways, the question, and the first person who puts the answer on the chat. Okay. What is an estoppel certificate? Whoever answers first correctly, and I won't be too exact. You get the gist of it. I'll give you guys the gift. So, what is an estoppel certificate? What is an estoppel? There's a question. First one to answer something similar, close. Is everybody sitting on their keyboards typing something? I can't tell. Should we give a time limit, Calvin?
Yeah, there's 2 answers. One written by tenants indicating outstanding issues of applications. Another one is between existing landlord and tenant to show everything clear.
Oh, Teddy. I think Teddy's got it. He's got the good gist.
All right, there you go. Teddy.
So Teddy, one thing you can do, and you can type your email on the chat here. And what happens later on is that I'll connect up with you and put the email right on the Amazon. They send it right out to you. And then once you accept it, they'll, unless you don't shop Amazon. Do you have Amazon? Teddy? Yeah. Okay. We're good. And you can also send it to Calvin and then send it to me as well. Sounds good. Congratulations. Yeah, Sophie, you're good too, but you just were second, so sorry. Okay, we're good. Is that it? Well, before I end, I just want to say thanks for showing up and listening to me today regarding this topic. And if you have any issues dealing with any current issues, and feel free to reach out to me. One thing I want to tell you guys too is that you can text me. I also have WhatsApp. I don't use WeChat that often, but I do have it. The code is on the screen that you see right now. You can also text to me, and then I can send you some links to my WeChat and codes and stuff. And but I prefer text, emails, and WhatsApp. Okay, sounds good. Calvin, anything else?
No, that's it. Thanks, Ivan.
Yeah, so you guys, if
Thanks,
you have
everyone.
any further issues and things you want me to come on and talk about, make sure you let Calvin know, and then we'll go from there.
Okay, thank you.
Okay. Oh, thanks, Joanne.